Well, concerning the structure of the tax treaty against double taxation adopted, the model adopted from the Organization for Economic Cooperation and Development, the structure of the treaty. So there is a general block, a block of tax events, and a final block. For our purpose, for the purpose of our lecture, what matters for us: business profits, corporate income, and dividends, right? So taxation in Brazil on the profits from foreign associated companies and from foreign controlled companies. The problem for who are in jurisdictions that don't have tax treaties with Brazil. Well, it's important we take attention because the greater than 50 billions in Brazilian ranks, right? The amount of the litigation concerning problems because the non-use of tax treaties, right? And the origin of the lawsuit. The lawsuits were caused by the Brazilian fiscal authorities based on profits of foreign associated companies and foreign controlled companies that were not distributed to the Brazilian parent company. So, the money are not into the Brazilian jurisdiction, but the Brazilian authority understand what? Well, happens profit in a foreign jurisdiction controlled by the Brazilian holding company. So this is like profit for this holding company, right? This is the main issue. And this number is on for the 10 public health companies, biggest public health companies in Brazil. So, to understand the importance of the treaty, what we need to do mentally. Let's imagine a Brazil and states without treaties here, in this side, and here with treaties against double taxation. So, this environment So this environment, we have a provisory normative act made by the executive Brazilian power and first enacted in 2001 with force yet in 2012. It's an absurd. Why? Because the essence of this kind of norm is what? The provisory, right? What are the soul of this norm? In order to determine the calculation based on income tax and contribution on net profits, the profits earned by controlled or associated companies abroad will be considered available for the Brazilian parent company or for the Brazilian associated company at the date in which they were measured in the balance sheet. So, the money are in the foreign jurisdiction but the Brazilian authority wants that the Brazilian holding company considers these profits, even the money are not in a Brazilian jurisdiction. So what happens? Of course, a direct inconstitutionality action before the Brazilian Federal Supreme Court against this norm, right? And one of the arguments were that the foreign profit only can be taxed when effectively available for the Brazilian company. What happens when they enter into the Brazilian jurisdiction? But this is something that I think that will die according the movement of the world. Why I'm telling this? Because there is a world tendency, right? And of course the facts, fact sheet, facts, the action, the appeal in the Brazilian Supreme Court are under judgment by more than 10 years, with a equal score, depending the vote of only one more justice. That is the Justice Joaquim Barbosa. As well as a more recent extraordinary appeal at the same issue will probably follow the word tendency. What's the word tendency? CFC rules, controlled foreign corporation rules, right? Why? Lions eat food. Of course, in general perspective, I intended to consider the profits earned by a foreign controlled company as part of the parent company for tax purposes. So, if we are in an environment, a business environment, with states without treaties with Brazil, it's impossible do business internationally. So, what's the first step? Let's find the jurisdiction in which Brazil celebrates a treaty. So we have 29 jurisdictions. As you can see. Well, let's talk about Belgium. So let's come back and let's imagine the environment of this side. Brazil states with treaties. What happens? When a resident of Brazil receives income which according to the treaty are taxable in Belgium, Brazil will give to the taxpayer an equal credit to the taxpayer in Belgium. In other words, if the Belgian authorities taxed some fact of a person, and this person a resident in Brazil, the Brazilian authorities will consider an equal credit, right? So this is the article of the first test of the treaty. After 2007, we have an amendment of this test, and before the mechanism of credit, what that is the essence against